Imagine a listed company where the board is perfectly constituted. Six directors are sitting in the boardroom. The independent directors are in place. The company secretary has completed the compliance checklist. Everything looks perfect. But then one question changes everything. Who is actually watching the numbers? Who is challenging management? Who is protecting shareholders? Who is monitoring risk? Who can receive a whistleblower complaint? And who is making sure that the board is not making decisions without proper scrutiny? The answer is not just the board. The real story begins inside the board committees. And today, you are going to discover 5 committees that can completely change the governance structure of a listed company. Audit Committee, Nomination and Remuneration Committee, Stakeholders Relationship Committee, Risk Management Committee, and the Vigil Mechanism. By the end of this lecture, you will know the exact composition requirements, independence requirements, chairperson requirements, meeting frequency, quorum, powers, responsibilities, and practical compliance points under Regulation 18 to Regulation 22. And I want you to stay until the end, because the final question will connect all these committees into one practical secretarial audit test. Welcome back to Corporate and Securities Law Compass, Navigating the Law with Clarity. This is the SEBI LODR Master Series, Lecture 7. Today, you will learn. Today, we are moving from the boardroom into the committee room. We will start with Regulation 18 and understand the Audit Committee in detail. Then we will move to Regulation 19 and understand the Nomination and Remuneration Committee. After that, Regulation 20 will take us to the Stakeholders Relationship Committee. Then we will enter Regulation 21 and understand the Risk Management Committee. And finally, we will understand Regulation 22 and the Vigil Mechanism. For every committee, we will ask the same questions. Who must be on the committee? How many members are required? How many must be independent? Who can be the chairperson? How often must the committee meet? What is the quorum? What powers does the committee have? What information must be reviewed? And what should a company secretary check during compliance review and secretarial audit? So let us begin. The story begins. Imagine ABC Limited, a large listed company. The board meets regularly. Business is growing. Investors are watching. But one day, the audit committee receives information that something does not look right. A financial number needs deeper examination. A related matter requires scrutiny. An internal audit observation needs follow-up. Now the question is, who is going to investigate? Who has the authority to ask for information? Who can call the internal auditor? Who can seek professional advice? And who reports the matter back into the board governance system? This is where Regulation 18 begins. Regulation 18, Audit Committee. The first principle is simple. Every listed entity shall constitute a qualified and independent audit committee in accordance with the terms of reference prescribed under the regulation. Now let us break this down. Qualified, independent, and properly constituted. The audit committee is not simply another committee created because the law requires a committee. It is one of the most important governance mechanisms inside a listed company. Composition of Audit Committee. The Audit Committee must have a minimum of 3 directors. Now comes the independence requirement. At least 2/3 of the members of the Audit Committee must be independent directors. And where the listed entity has outstanding SR equity shares, the Audit Committee is required to comprise independent directors as specified in the regulation. This means the presence of independent directors is central to the Audit Committee. Why? Because the Audit Committee must be able to challenge management. It must be able to question financial reporting. It must be able to examine internal controls. And it must be able to review issues without inappropriate management influence. Financial literacy. Now comes another important requirement. All members of the audit committee must be financially literate, and at least one member must have accounting or related financial management expertise. But what exactly does financially literate mean? The regulation explains it. Financial literacy means the ability to read and understand basic financial statements, including a balance sheet, profit and loss account, and statement of cash flows. Think about the logic. If the committee is responsible for reviewing financial information, its members must be able to understand the financial statements being placed before them. Practical example. Suppose ABC Limited places its quarterly financial results before the audit committee. One member sees the balance sheet. Another sees the profit and loss statement. Another examines cash flows. If the members cannot understand these basic statements, can they effectively challenge management? That is exactly why the regulation requires financial literacy. Accounting or financial management expertise. The regulation goes one step further. At least one member must have accounting or related financial management expertise. The explanation also recognizes experience in finance or accounting, professional certification in accounting, or comparable expertise or background resulting in financial sophistication. The purpose is clear. The audit committee should contain at least one person capable of going deeper into financial matters. The chairperson. Now imagine you are looking at the audit committee structure. You have the required members, you have independent directors, you have financial literacy, but who is chairing the committee? The chairperson of the audit committee must be an independent director. This is another important independence safeguard, and the chairperson should be able to provide leadership to the committee without inappropriate influence. Annual General Meeting. The chairperson of the audit committee must be present at the annual general meeting to answer shareholder queries. Think about what this tells us. The audit committee is not operating in complete isolation. Shareholders may have questions, and the committee chairperson is directly connected with the shareholder accountability process. Company Secretary. The company secretary of the listed entity acts as a secretary to the audit committee. This is extremely important from your practical perspective. The company secretary is not merely arranging the meeting. The company secretary becomes part of the governance process. Agenda, notice, board and committee papers, minutes, compliance tracking, follow-up, disclosure, and regulatory documentation. Who attends the audit committee? The Chief Financial Officer, the Head of Internal Audit, the representative of the Statutory Auditor, and other executives may be invited to attend the audit committee meetings. The internal auditor may also attend the meetings of the audit committee. But attendance does not mean voting rights. This distinction is important. People may participate in discussions, but committee membership and voting rights are different concepts. Audit committee meetings. Now comes one of the most frequently tested requirements. The audit committee shall meet at least 4 times in a financial year, and not more than 120 days shall elapse between 2 consecutive meetings. So remember the two numbers: 4 meetings 120 days. Do not memorize only 4. Because a company could technically hold 4 meetings but still have a problem if the interval between consecutive meetings exceeds the prescribed limit. Practical example. Suppose ABC Limited holds audit committee meetings in April, August, December, and March. At first glance, 4 meetings. Looks compliant. But now calculate the actual gap between consecutive meetings. If any interval exceeds 120 days, the company secretary must examine the compliance position. This is why meeting frequency is not just about counting meetings. It is about counting time between meetings. Audit Committee Quorum. Now imagine the audit committee meeting is scheduled, but only 2 people arrive. Can the meeting proceed? The regulation provides that the quorum shall be 2 members or 1/3 of the members of the audit committee, whichever is greater, and at least 2 independent directors must be present. So you must calculate both requirements, number-based quorum and independent director presence. This is a classic secretarial audit checkpoint. Powers of Audit Committee. Now we reach one of the strongest parts of Regulation 18. The Audit Committee has the power to investigate any activity within its terms of reference. It can seek information from employees, it can obtain outside legal or other professional advice, and it can secure attendance of outsiders with relevant expertise if necessary. Think about that. The Audit Committee is not simply receiving information. It has investigative powers. Suppose the Audit Committee sees something unusual. It can ask questions. It can seek documents. It can speak to employees. It can obtain professional advice. And it can investigate matters falling within its terms of reference. That is why the Audit Committee is one of the most powerful governance committees. Role of Audit Committee. The role of the Audit Committee and the information to be reviewed by it are specified in Part C of Schedule 2. This is an important exam and practical point. When studying Regulation 18, do not stop at the regulation itself. You must also connect it with Schedule 2. Regulation tells you the framework. Schedule 2 tells you the detailed role and information to be reviewed. The story moves forward. The Audit Committee has done its work. But another question now appears. Who decides whether the right people are sitting on the board? Who considers appointment? Who considers remuneration? Who considers succession and performance-related matters? Now we enter Regulation 19. Regulation 19. Nomination and Remuneration Committee. The Nomination and Remuneration Committee must have at least 3 directors. The committee must comprise non-executive directors, and at least 2/3 of its members must be independent directors, subject to the applicable provisions of the regulation. Now compare this with the Audit Committee. Audit Committee minimum 3, at least 2/3 independent. Nomination and Remuneration Committee minimum 3, non-executive, at least 2/3 independent. So already you should see a pattern. SEBI is building independence into the committee structure. Chairperson of NRC. The chairperson of the Nomination and Remuneration Committee shall be an independent director. Again, independence. This is not accidental. The committee deals with appointments, remuneration, and governance-related matters. So the chairperson must satisfy the independence requirement. Important proviso. There is an important provision relating to the chairperson of the listed entity. The chairperson of the listed entity, whether executive or non-executive, may be appointed as a member of the Nomination and Remuneration Committee, but that person cannot chair the committee. This is an excellent examination question. A person may be a member but cannot be the chairperson in the circumstances specified. NRC meeting quorum. The quorum for a meeting of the Nomination and Remuneration Committee is 2 members or 1/3 of the members of the committee, whichever is greater, and at least one independent director must be present. Again, do not simply ask, are 2 directors present? Check the 1/3 requirement. Then check whether at least one independent director is present. AGM. The chairperson of the Nomination and Remuneration Committee should be present at the annual general meeting to answer shareholder queries. But there is an important proviso. The chairperson of the committee may be absent from the AGM in circumstances permitted by the regulation. Again, read the main provision, then read the proviso. That is how you should study SEBI LODR. Meeting frequency. The Nomination and Remuneration Committee shall meet at least once in a financial year. One meeting is the minimum requirement stated in the provision. But remember, minimum does not mean sufficient for every practical situation. The committee should meet whenever necessary to discharge its responsibilities effectively. Role of NRC. The role of the Nomination and Remuneration Committee is specified in Part D of Schedule 2. So again, Regulation 19 plus Schedule 2. That is the complete compliance picture. The next governance question. Now the board has an audit committee. The company has a nomination and remuneration committee. But who listens to investors? Who handles grievances? Who looks after security holders? That brings us to Regulation 20. Regulation 20. Stakeholders Relationship Committee. The listed entity shall constitute a Stakeholders Relationship Committee. The purpose is connected with resolving the grievances of security holders. Now look at the composition. The committee must have at least 3 directors. At least one member must be an independent director. And in case of a listed entity having outstanding SR equity shares, the applicable higher independent director requirement under the regulation must be considered. Chairperson. The chairperson of the Stakeholders Relationship Committee shall be a non-executive director. Notice the difference. Audit Committee Chairperson, Independent Director. Nomination and Remuneration Committee Chairperson, Independent Director. Stakeholders Relationship Committee Chairperson, Non-Executive Director. This is exactly why you should never assume that every committee has identical requirements. AGM. The chairperson of the Stakeholders Relationship Committee should be present at the annual general meeting to answer questions of security holders. Meeting. The Stakeholders Relationship Committee shall meet at least once in a financial year, and the role of the committee is specified in Part D of Schedule 2. Practical example. Imagine ABC Limited receives multiple investor complaints: dividend-related issue, transfer-related issue, dematerialization issue, shareholder communication issue. Who should oversee the grievance resolution framework? The Stakeholders Relationship Committee. This is why the committee is directly connected with investor and security holder experience. The story gets bigger. Now imagine something more serious. The company has financial controls. It has investors. It has a board. But what about risk? Cyber risk, operational risk, financial risk, business continuity risk. What happens if the company identifies a major risk but nobody at board level is monitoring it? This takes us to Regulation 21. Regulation 21. Risk Management Committee. The Board of Directors shall constitute a Risk Management Committee in accordance with the requirements of the regulation. The committee must have at least 3 members. A majority of the members must be members of the board of directors. And the committee must include at least one independent director in the circumstances specified in the provision. Chairperson of Risk. K. Management Committee. The chairperson of the Risk Management Committee shall be a member of the board of directors. Senior executives of the listed entity may be members of the committee. Again, do not assume the chairperson requirement is identical to the audit committee. It is different. Risk Committee meetings. The Risk Management Committee must meet at least twice in a financial year. So remember, Audit Committee, at least 4 meetings, NRC, at least 1 meeting, Stakeholders Relationship Committee, at least 1 meeting, Risk Management Committee, at least 2 meetings. For quorum, check 2 members or 1/3 of the committee, whichever is higher, with at least 1 board member present. Also check the maximum 180-day gap between consecutive meetings. The Risk Management Committee monitors and reviews the risk management plan, assesses related risks, and covers cybersecurity within the applicable framework. Imagine ABC Limited suffers a major cyber attack. Customer information is affected. Now the question is not just what went wrong. The real question is, was the cyber risk properly identified, monitored, and reviewed by the Risk Management Committee? Systems are disrupted. Business operations are impacted. The question is not only how did the attack happen? The governance question is, was cyber risk identified? Was it included in the risk management framework? Was the Risk Management Committee monitoring the risk? This is why cybersecurity is now an important part of board-level risk governance. Applicability. The specific Risk Management Committee provisions in the source material apply to the top 1,000 listed entities and high-value debt-listed entities. So again, classification matters. Before applying the provision, identify whether the listed entity falls within the applicable category. Powers of Risk Management Committee. The Risk Management Committee has the power to seek information from employees. It may obtain outside legal or other professional advice, and it may seek information from persons with relevant expertise if necessary. So just like the Audit Committee, the Risk Management Committee is not merely a discussion forum. It has a governance function supported by information gathering and professional advice. The final layer. Now we have reached the last part of today's story. Imagine an employee discovers something seriously wrong. Financial misconduct, improper behavior, a governance violation. The employee wants to report it. But there is a fear. What if the employee is punished? What if management retaliates? What if nobody listens? That is where Regulation 22 becomes critical. The listed entity must provide a vigil mechanism for directors and employees to report genuine concerns. But reporting alone is not enough. The mechanism must provide safeguards against victimization. And in appropriate exceptional cases, there is direct access to the Audit Committee chairperson. Now bring the story together. ABC Limited has an Audit Committee for financial oversight. It has an NRC for appointments and remuneration. And it has a vigil mechanism to ensure genuine concerns can reach the right governance level. The question is not whether the mechanism exists. The question is whether employees can actually use it without fear. The Stakeholders Relationship Committee addresses security holder grievances. The Risk Management Committee monitors risk and cybersecurity. The vigil mechanism provides a channel for genuine concerns. Now think about the bigger picture. If all 5 mechanisms work properly, the board gets better information, management faces stronger oversight, Investors have a grievance mechanism, and risks receive board level attention. That is the governance architecture under Regulations 18 to 22. Now, your question. ABC Limited has 3 audit committee members, but only one is independent. Is that compliant? Think carefully. Comment yes or no. The answer is no. Under the provision, at least two-thirds of the audit committee members must be independent. For a 3-member committee, that requirement becomes critical. Check role under Schedule 2. For Regulation 19, check the Nomination and Remuneration Committee. Minimum 3 directors. Non-executive composition. Independent director requirement. Independent chairperson. Quorum. Annual meeting requirement. And Schedule 2 responsibilities. For Regulation 20, check the Stakeholders Relationship Committee. Minimum 3 directors. Independent director requirement. Non-executive chairperson. Annual meeting. And security holder grievance responsibilities. For Regulation 21, check the Risk Management Committee. Minimum 3 members. Majority board members. Independent director requirement. Board member as chairperson. Minimum 2 meetings. 180-day maximum gap. Quorum. Risk management plan. Cyber security and applicability to the specified listed entities. For Regulation 22, check the vigil mechanism. So the real question is no longer, does the company have committees? The real question is, are those committees properly constituted, properly meeting, properly empowered, and actually performing their regulatory role? And that is where the next level of SEBI LODR compliance begins. Because knowing the composition is only half the story. The next question is, what exactly must each committee do? And what information must come before them? That is where our Master Series continues. If you found today's lecture useful, subscribe to Corporate and Securities Law Compass. Navigating the law with clarity. This is the SEBI LODR Master Series. Lecture 7. Keep learning, keep questioning. And whenever you read a regulation, do not stop at the main provision. Read the sub-regulation, read the proviso, read the explanation, read the schedule, and understand how the provision actually works inside a listed company. I will see you in the next lecture.